Today, we're going to be discussing the Digital Omnibus package as it relates to GDPR and AI. So basically, this is a package of measures which is aimed at lifting burdens on businesses, enhancing competitiveness of the EU on the worldwide stage, basically. We'll have a look through and decide whether we feel that that's been accomplished by this. So Jenai will be covering proposed changes to the GDPR. Then I'll have a look at changes to the AI Act. And Alison will finish off with a session on discussing how we go about dealing with these increasing divergences, so both UK, EU, worldwide, and how we navigate that to ensure that we are complying with all the regs we need to comply with. Just to say that if you have questions, please feel free to pop them into the Q&A box, and we'll have a Q&A session at the end. But if you'd rather, obviously, you can raise them with us by email after the webinar. I'm very happy to receive them that way as well. So what I will do is I will hand over to Jenai and let her take it from here on the GDPR.
Thank you, Claire. So good morning, everybody. I'm going to do a very fast run through the changes that have been proposed by the Digital Omnibus. So I'm going to go through, start with, this is the, what did I say, blue sky thinking, and every cloud has a silver lining, as I like to think about it. So the view from the European Commission is that this is going to be a regulation which is going to be the saviour for organisations. You no longer need to worry about compliance. It's going to streamline the way that privacy is handled. It's going to make data subject rights much easier. But in reality, I think we should probably see what the Commission think versus what the EDPB and the EDPS. I'm going to get these confused. So I'm just going to refer to EDPB throughout, but I mean the supervisory part of it as well. So as I go through, I'll set out what the key requirements are and changes, and we will do a more in-depth session of this, because when I was going through the slides, I was thinking we could have a whole hour on some of these changes. And if anyone's got questions or comments at the end, feel free to add those in. So the key changes then. So in practice, this means that some of the principles of the GDPR are going to be streamlined. This is not supposed to be a rewrite of legislation, but it's supposed to provide clarity. And the thinking behind this was that as we've had some case law on different points, for example, when is personal data, when does pseudo-anonymisation make personal data unidentifiable, the Commission's principles really are to codify some principles and maybe tidy up some areas where potentially there has been some confusion. And they think rather than doing this via guidance through the EDPB, it should be codified in law. And this is where I think the big contention is between the EDPB and the EDPS. So what we'll go through is we'll have a look at each of these. So the first thing that we're going to have a look at is the definition of personal data. In the Digital Omnibus, they want to clarify the definition of personal data, set out scenarios where personal data is not personal data, for example, when it's passed to another organisation and they cannot identify it, or if the data has been pseudo-anonymised and therefore is no longer identifiable. And what they've tried to do is come up with some, rationale behind this and some reasoning as to how this will work in practice. And this slide actually links to the next slide for pseudo-anonymisation. However, the EDPB and the EDPS have concerns that this is weakening the definition of personal data and actually erodes when data is personal data for the purposes of the GDPR. So therefore, they have proposed a number of changes to the legislation. And again, I won't go through every one of these because it's very detailed in nature, but there have been some criticism. So on this one, the definition of personal data, I would definitely say EDPB and EDPS, probably lukewarm, not 100% on board with the exact wording at the moment. And the same goes for anonymisation and pseudo-anonymisation clarity. So what the Digital Omnibus is proposing is that there are criteria which are introduced, which then say, well, if you do this, this and this, then the data will be anonymised or pseudo-anonymised. And I've simplified that because there are some caveats. However, again, the EDPB and EDPS have concerns that this, again, is likely to lead to the weakening of what is personal data and actually can result in more complexity as to whether or not something is personal data. And they believe that whilst clarification is needed, it's better done through the guidance that they already issue as well. So there's 2 points where definitely lukewarm on those. The next one, scientific research, and very happily the EDPB and EDPS are very happy with the proposal. And so what this proposal is providing a definition of what scientific research is to make it easier for organisations to understand whether or not what they're doing falls within that definition. And it's actually quite interesting if you read the opinion on the omnibus and actually what the legislation is trying to do. So I think this is a very good proposal, not in terms of every single detail of it. It does need to be refined, but hopefully this will give more clarity for organisations to use data for good, for example, preventing another outbreak of COVID, or for, potentially introducing drugs that can combat things like dementia in old age. So I think this is a good thing. So they're generally happy, but they do want further details as to what constitutes scientific research in the context of the GDPR, and not just the GDPR. We are covering this today, but also the EU DPR as well is covered. They consider the fact that individuals whose personal data is processed for scientific research may have different rights because the purposes for which the data is then subsequently used for scientific research may have been different from the purposes for which it was collected initially. So it's important to understand if the data is being used, if it is still personal data when it's being used for scientific research. They want some more clarification and controls around that, which is good. They also welcome another key change, which is the processing of biometric data, which can now be used subject to safeguards for uniquely identifying an individual, provided that the individual has control of that, but it should be reasonable and proportionate. So again, I think with the use of biometric data, it's already been always a bit of an interesting one when it's just only being used to identify somebody, say for security, when they're logging into something. So that's quite interesting. So they are medium on this one, I would say. The legal basis for AI, they're generally happy. So EDPB and the EDPS agree that the changes are welcomed. However, there is the caution that if you are using personal data, special category data for any development or operation of AI, that you still need to consider, if it is for legitimate interest, that you are carrying out the 3-part test still, and that you have to be able to demonstrate that it is legitimate interest, and you don't just go ahead and do that without considering the assessment. There's also an additional change relating to the unconditional right to object for the use of data, where this is for the development and operation of AI as well. So rather than having with the legitimate interest, you have the right to object, and the controller can say, actually, our right overrides, it doesn't detriment you, so we're going to carry on. It's the unconditional right which has potentially been introduced, and they want some clarification around that as well. And then there's some additional wording in there about using special category data for the use of development, operation and training of AI. If this is ancillary or a byproduct and not the actual target, saying that you can rely on AI. But again, the EDPB and EDPS do want some further clarification on this because it's still not super clear in the draft text. So I'd say lukewarm to this one as well. So the next one we have is data subject access request. And this one made me laugh when I read about it, and because I think this is an understatement. But in some cases, the right of access is being used in an abusive manner. I'm yet to see, and I will say this, a data subject access request which is not used in an abusive manner and is genuinely used because someone wants to know about how you're using your data. However, the concern from the EDPB and the EDPS is that by introducing this concept of abuse, it's open to interpretation. So I think that they would like more definitions of what is meant in the context of what is an abusive request. And they said that rather than looking at the abusive request side of things, they would like clarification of whether or not the purpose behind it is being used in an abusive manner. So if you can demonstrate that it's being used to slow down a business or cause detriment, then that is something that should be considered. They've also commented on this point about the excessive requests, so manifestly and unfounded. In the UK, obviously, we have lots of guidance, but I still agree there are certain scenarios which aren't covered sufficiently. And so what they have tried to do is cover some of the excessive requests, but they have also cautioned the fact that, again, organisations must be able to demonstrate why a request is manifestly unfounded or is of a character that we say is excessive. And you must also give an individual the opportunity to disagree with your request, which I think most organisations that we work with certainly do. So I'd say that they're generally happy with this one. We then got the requirements for privacy notices. So this is the reduction in the need to provide a privacy notice for small businesses or where the individual already has this information. I don't think this is a valuable amendment. So whether or not the EDPB do or the EDPS does, I think this is going to lead to a rise in the number of individuals making data subject access requests. And from our point of view, small and medium enterprises, they're normally, or smaller businesses, they're normally the types of organisations that don't have the privacy expertise. And the things with privacy policies and notices that I find useful is that they do make somebody stop and think about how you're using data before you do anything. So I think this is a bit of a dangerous amendment, because I don't believe that those organisations will necessarily have the information to look at whether or not they can use it lawfully or where it goes to. And I think this will lead to a rise in data subject rights. So it would be interesting to see what comes up from this. If it does end up being in the final draft, the feedback from the EDPB and EDPS is that there doesn't seem to be much benefit, but maybe there should be some clearer circumstances as when this, should apply. So again, I don't think they think this is an amazing amendment, and neither. The next one is automated decision making. They're generally happy with this, and this is the requirement about rather than, so the Omnibus talks about having a list of scenarios where you can carry out automated decision making. But the current principle under Article 22 is that there's a general prohibition, and that has been viewed by the courts that is a prohibition, so you cannot do it. And then the infringement doesn't need to be invoked by the individual, so they don't need to take steps. The general rule is that you shouldn't do it unless, there are specific, factors that mean that you can. Whereas now the changes seem to be that there'll be a list of certain scenarios where you are permitted to carry out automated decision making. I think the understanding behind this is that there is a concern that if a human could be in the loop, then the assumption is it could be or should be undertaken by humans. However, I think in practice that's not always possible. So again, whilst they understand the underlying intent, they are concerned about the move away from the principle as a whole, which was that there was a prohibition on automated decision making, whereas now it feels like that has been weakened by saying actually you can do it for specific circumstances. So that will be a change for individuals' rights. So the next one, data protection impact assessments. This is one that they are very happy about, and they think it's great that we're going to have harmonisation. So this is the introduction at EU level anyway of a single national list of high risk processing and when a DPIA should be carried out, and also a white list setting out circumstances where a DPIA is not required. The only concern that there is with this is that it said there was a proposal that the Commission, it's actually a proposal the EDPB create these, and then the Commission has a right to review and input into these. However, the view from the EDPB and the EDPS is that they should have the unilateral right to create these documents and these templates and not then be at the behest or the will of the Commission to, amend those or potentially rewrite them. So again, I'll amend the slide. It should say EDPB on there. But generally, I'm in favour of this, a list of when a DPIA is required. And Alison will talk about global scenarios for uses of data as well, and why this is useful if you're operating globally. Last two that we come to is data breach notifications. So Claire's got a quick poll on this before I forget. I forgot about my polls this morning. So according to a survey, how many data breaches were reported a day to the data protection authorities between January 2024 and January 2025? This is a day. How many data breaches a day? What do people think? Oh, people are going down in their estimations. It was 363 a day that have been reported. I mean, this doesn't cover ones that probably should have been reported that weren't, but yeah, so that is quite a high number as well. So there are some really significant changes. And I think to be honest, this is one that the EDPB and the EDPS are very much in support of. So the big two changes are the increase of the threshold. So then only high risk data breaches will be reported. You'd still do the assessment and you still have your log internally of those breaches. And if you have a DPO like us, who are very active, and we will monitor what you're doing and we won't just take your word for it, we will be looking at your logs to make sure that you are still reporting high risk when you need to. And there's no expectation that this will substantially impact the individuals, because as long as organisations are assessing those breaches then and making sure that they're not reoccurring, then it should be fine. The other one is the change in reporting from 72 hours to 96 hours. Again, they're in support of that change as well. I do think from having handling breaches, that's a very short time period for individual reporting. And also I think what this will do is reduce the number of reports that are saying, oh, we think there's been a breach, we're notifying you now, we'll update you. And there probably are a number of reports where all of a sudden it's not a breach, but people are over reporting because they want to comply. So this is quite good. And they also support the obligation that the EDPB is going to be providing a template breach form, which is very good, and also a list of circumstances in which a breach is going to be reportable as well. And then another point to raise on this is just for the different reporting regimes that there are, about having one point for Europe. Unfortunately, because we're not in the EU, the ICO may be slightly different, but certainly for EU, one place to actually report breaches now, which is quite handy. And hopefully that will mean that one form's completed. But again, I think this needs fleshing out a lot more than that's in the proposal at the current time. And then finally, for me, I couldn't find a picture of a cookie, but I thought we'd have a cake, because finally, maybe we can have our cake and finally eat it. So cookies. So the poll was basically about how many individuals just randomly accept cookies because they can't be bothered, or just reject them. It was about, yeah, it's probably about 80%. Yeah, it was the amount of people that do. Although I try not to, I try to go in and reject, and then they go do your preferences, and then they're very cleverly, because of like the IAB, hidden them. But sometimes Steph, they don't work unless you accept them. So it's very frustrating. So yeah, I just give up and then clear my cookies each time. So yeah, but I'm sure everybody's as annoyed about cookies as I am. And I think this is quite good. So the EDPB and the EDPS support the aim of the proposal, but there are concerns over conflicts with different laws. And this is because some of the protections, I think it's the EU DPR, covers the protection of information which is potentially not personal data, but it's still beyond the dice. And then you've also got the e-privacy directive, which covers personal data when cookies, even if they don't contain information to identify an individual, any placing of technology on that device is still covered. I haven't looked at this in detail just because I've reread the e-privacy directive since 2014, waiting for it to change in accordance with GDPR, and it hasn't since. So as I joked to Claire and Alison, I refuse to read the final wording of this until it's final, because everything changes. But again, the general principle is, and we've heard about this, and this is where it goes to blue sky thinking versus reality, about actually having an automated system that has embedded into our browsers this function where we can actually decline cookies, and it applies across every single kind of like website and application. I'm not entirely sure how this will work, but I do think some form of automation would be good. So when an individual declines cookies for a website, say for marketing, if they don't want to receive it for anybody, then I think that would be good. Good for us as individuals, not great for businesses. And also some individuals do want marketing from some organisations. So I think there's a bit of a balance here as to what is annoyance, fixing, versus what is going to detriment an individual by not having offers, say, for example, that they could have had and paying for higher prices for products and services. And there's quite a few things. The part on cookies, because I don't want to take too much of Claire and Alison's time, is actually quite lengthy. And I do think this is one where they are not going to agree on the proposal as it is. So I haven't gone into too much detail, but the whole purpose is to align and get through rid of cookie fatigue. And also the final point is allowing consent for certain types of cookies, for example, where you've got IT. So always allowing, for IT security, for cookies to be set to make sure that devices are secure and safe, or running patches and updates. So that was it from me. So as you can see, the EDPB, EDPS are generally happy, but have some concerns. Some bits I'm not very happy, but it'll be interesting to see what organisations think. Probably when you hear Alison's bits, you'll probably be your head will be in your hand about more legislation. So, okay, Claire, over to you.
Thanks, Jenai. So I'm going to have a look at how the Digital Omnibus affects the EU AI Act. Now, I'm not going to go over the territorial scope, but just a quick reminder, obviously, that it's not just systems which are in the EU, it's wider than that. But I thought we'd do a quick reminder of some relevant terms from the AI Act, just for everyone's benefit. So first of all, we have AI system, which is a machine-based system that's designed to operate with varying levels of autonomy, and it might adapt after deployment, and that it infers basically from input that it receives how that it should generate outputs like predictions, content, recommendations, and decisions which can have effects in the real virtual world. Now, a provider is a person or an entity that develops an AI system or a general purpose AI model, or has it developed and places it onto the market, or puts the AI system into service under its own name or trademark, and that can be whether for payment or free of charge. So I think you can see the risks of falling into that category. It's not purely just the person who creates it. If you put it on the market under your own name and your trademark, or you make significant alterations to those kind of systems, you fall at risk of becoming a provider of an AI system, and that's relevant in terms of what obligations there are under the Act. So deployer, that's a person or entity that uses the system, except where it's used in a personal, non-professional activity. So that's, where you haven't, gotten off the shelf using it within your business, for example. So, and again, another quick categorization. So this is how the AI Act categorizes systems, AI systems. We have first unacceptable systems, which are carrying an unacceptable level of risk. So they can't be placed on market, put into service or used. And so this is already enforced, these requirements. Then we have high risk systems, which have a lot of obligations under the AI Act for providers and deployers. Limited systems, which have some transparency. Some systems have transparency requirements if they interact directly with individuals, for example, or they create content. So like deepfake type situations, things like that. And then minimal, which can be used freely, and it's not set out in the legislation itself, but it's not governed. And just very quickly with the unacceptable systems, they're things that materially distort human behavior and things that have significant adverse harm related to them. Subliminal techniques, manipulation of people, exploiting vulnerabilities of people, children, people who don't have proper mental capacity. Social scoring, sort of inferring predicted personality characteristics. Biometric identification and categorization for law enforcement purposes. And then sort of biometric categorization to deduce or infer certain special category data like race or religion, trade union membership. Profiling to assess the risk of committing criminal offences. There are some narrow exceptions to some of these I should mention. Emotion recognition, so creating facial recognition databases or inferring emotions in the workplace or in education environments. High risk, sorry, this is a lot to cover, but I just wanted to make sure that everyone was on board with me when I was talking about it later on. High risk, we've got two categories. So we've got one category which is in Annex 1, which is where it's a component which is intended to be used as a safety component in a product or system, or it is the product or system itself, and it's covered by union legislation, which is harmonization legislation. So for example, we have sort of machinery, toys, lifts, radio equipment, some medical devices. They are covered already by union legislation on their safety, and so they fall into one category. And then we have Annex 3, which are sort of standalone systems that have a risk of significant harm to health, safety, or fundamental rights of individuals. So here we've got sort of 8 major areas of risk. So we've got biometrics, critical infrastructure, education and training, employment and worker management, access to essential services, law enforcement, migration, asylum, border control, administration of justice, and democratic processes. So basically that's what the high risk covers. There are exemptions which can take you out of the high risk category in Annex 3 if you're just basically doing sort of either preparatory tasks, things that are not supposed to influence the decision of a human. There will be a human involved there in the future. So, or doing sort of detecting duplicates, so to narrow procedural tasks. So there are exceptions, which means that even though it would otherwise be high risk, it doesn't fall into that category. So having gone through that, what are the key changes of the Digital Omnibus? Well, we've got them just in brief here. So delay in implementation of the high risk provisions, carve-outs for small and mid-cap organisations, expansion of real-world testing for high-risk systems, changes to the AI literacy requirement, postponing of certain transparency obligations, clarity on conformity assessments, and special category data for bias detection. So looking at the high risk requirements, so we looked at what high risk systems were, and in terms of the requirements, obviously providers have a large list of requirements they have to fulfill so that the systems themselves are compliant with the requirements of the Act, and they also have a number of other requirements in relation to that. Deployers equally also have requirements that they have to comply with. I just don't have time, I'm afraid, to go through them at the moment, but we did go through in more detail in our EU AI Act webinar, which is available on our YouTube site if you want to kind of dig into that. But basically, those requirements are being delayed until the EU Commission adopts a decision confirming that there's been enough guidance and specifications to ensure that people can meet those requirements. I think there was a lot of pushback, as you may well have been aware, since last year in relation to this. So hopefully we'll have a confirmation of that, and then after the adoption date there'll be transition periods. So Annex 1, those sort of safety components and things covered by other types of union law, will be 12 months. Annex 3, we've got a 6-month transition period to bring those into force. But backstop deadlines they do have of the 2007, yeah, 2027, not 2007, in Annex 3, and the 2nd of August 2028, Annex 1. Small business carve-outs. So here we have several small business carve-outs. So we've got simplified technical documentation for high-risk business providers. That's going to be extended to small mid-caps. So small mid-caps organisations which have up to from 250 to 750 employees and a turnover of 150 million or a balance sheet of 129 million. Those will be, so the simplified technical documentation that you have to produce for your system to make sure it is, to show that it's compliant, will be extended to those small mid-caps, and a form is being developed to help with this. Quality management systems for providers. So small enterprises and small mid-caps are particularly called out when they talk about the implementation of a quality management system being implemented in a proportionate way. The third one is the quality management system. The simplified system compliance will be extended to small organisations. Before it was just micro organisations, and there will be guidance provided on how to comply with that. So moving on to the next, AI literacy update. So the Commission member states are now going to be encouraging providers and deployers of AI systems to take measures to ensure a sufficient level of AI literacy of their staff and other persons dealing with the operation of AI systems. So that's instead of the current, which is currently enforced, the current requirement of providers and deployers to do that. So this has moved. The EDPB is not particularly keen on this, which is possibly understandable. I don't know whether it's helpful really, because I think people need to understand how to use AI and how to use it in a way that's compliant with the AI Act. So it's difficult to see how that really will help moving it up to a sort of an encouragement situation. I think there is a possibility that it provides more flexibility potentially, but yeah, maybe not the most helpful. So conformity testing and registration. we've got an increase in the real world testing of high risk systems. So previously it was just the Annex 3 systems. It's been extended to Annex 1, so they can be tested in real world scenarios as long as there are sort of these testing agreements which will be agreed between member states and the Commission. And the sectoral, there is also, in terms of conformity assessments, there is where you have a system which is covered by both an Annex 1, so a sort of this safety legislation or legislation which is cross-European, but also falls within Annex 3. So, for example, it might be sort of a medical device that has some sort of facial recognition elements. They have confirmed that you only have to do the sectoral conformity assessment, and that will take precedence where there's a conflict between the two. So you don't have to do both of them. So that should simplify things. And they have also said that the sectoral designations, the sectoral bodies who are now confirming conformity can kind of continue to do so, even if they haven't yet been appointed as official sort of notified bodies for the purpose of the AI Act. Now, we have providers of, so earlier I talked about the high-risk systems and the fact that there are certain high-risk systems which, because you fall under an exemption, you wouldn't be classified as a high-risk system. So under the current Act, without the Digital Omnibus, providers of those systems would have had to register those systems and sort of provide reasons why they fell within the exemption, so that they could sort of be available publicly. So the Digital Omnibus removes that requirement for the registration. The EDPB is not happy with that. They think that there's less accountability, more tendency perhaps for people to use these exemptions, thinking they can perhaps get away with it without too much scrutiny. I think if this does get through, then obviously as deployers, you might want to think about including a due diligence question to cover whether the provider has, what the provider's reasoning is for thinking that the system is covered by the exemption that they're claiming. Transparency in Gen AI. So this concerns the providers of AI systems that include the generation of synthetic audio, image, video, or text content, and which are placed on the market before the 2nd of August 2026. So that's the current sort of provision. So it basically is delaying that requirement delaying the requirement to ensure that they are marked in a way that it shows that they are artificially generated or manipulated, and that requirement is delayed until February, the 2nd of February 2027. A consultation there's going to be some guidance on how to do this, and the consultation has taken place and is shut, and so hopefully we will get some guidance on that shortly. So using special category data, so there is an expansion to permit the use of special category data for bias detection and correction in systems that are not high risk. So under the existing AI Act, you can do it for high risk systems, but not for other systems. So, and this can be used by both providers and deployers, and it's conditional on the fact that there's no alternative data to test with, even including synthetic data or anonymized data, that you need to have technical and organizational safeguards in place in relation to data reuse and in relation to data security. The data can't be transferred or accessed by third parties. It needs to be deleted after the bias is corrected or the end of the retention period, whichever's shorter. And the fact that it's necessary in order to detect or correct bias needs to be documented in your ROPA. The EDPB is not terribly happy with this. It wants a limitation to situations where the risk of adverse effects of the bias is sufficiently serious. They basically don't want people using it to check where the outcome of the effect of the bias would be actually minimal. And I guess it's the tension here between, you know, discrimination, use of data where we don't need to use it. And the EDPB also wants sort of further clarity on how it interacts with the GDPR, just so that everybody's clear on that point. So what do we need to do in light of these potential changes? So I think, as Jenna has said earlier, there's a long way to go. We're not there yet. Things may change. EDPB, EDPS have clearly made some sort of quite strong points in some areas and said, you know, not happy with certain things. Obviously, we should be aware that some requirements are already enforced. So the literacy requirement is already enforced. So we still have to comply with that at the current date, even if it is going to be changing. So again, that will, I guess, will have an effect on how useful we think it is to take it up to a commission level, to be giving that encouragement. We need to make sure people are tasked with checking for updates, because the guidance is coming out, updates within the legislative procedure. You know, we're not there yet, and basically changes will come. There will be changes, and so, you know, we don't want to sort of fling ourselves full force into thinking everything's going to be coming in, the high risk stuff, for example, in August, but we don't quite know what the changes are yet. Unfortunately. Right, and then I'm just going to finish off with a little poll, because I just was interested to know what you think of these changes to the AI Act, and whether you think that they're helpful, not helpful, don't know whether they're going to have an effect or not yet. Okay, so interesting. So I don't know whether you guys can see this sort of live results, but yeah, not clear whether the changes will be helpful or not yet. I think that's true. We're not there yet. We don't know whether what's going to come into force, what's not, in terms of whether it will get through the process. Thanks very much for that. Anyway, I'm going to hand over to Alison, who's going to complete the final section on the how to cope with differences.
Thank you, Claire. I find, just to reflect on something that Claire was going through there, I find it quite interesting, the approach to SMEs and sort of not requiring them to comply with some of that technical documentation bits, when SMEs are some of the people doing like really interesting, innovative, and probably very high risk developments in AI.
That's my whole point on the privacy notices. As I was like thinking about that, I was thinking, how long does it take to put a privacy notice together? We all know it's not a here it is. So if somebody gets a data subject access request with that information, they've probably not even thought about half the things you need to put in a privacy notice. So yeah.
The EDPB shares your concerns, Alison. You know, they made that point in their thing, that it doesn't, like, just because you're small doesn't mean that what you're using in terms of AI is any less complicated.
Yeah. Okay, well, I'm glad the EDPB is aligned with my thinking. Okay, I am going to try to make this session very practical, and I'm not specifically going to be looking at the sort of digital omnibus things in particular. We're going to take a bit of a higher level approach and look at divergence generally, and how you can manage diverging privacy regimes. So I think most people on this attending this webinar have responsibility for making sure that your organisation is compliant with privacy regimes. So before we dig into how you do that, I've got yet another poll, you'll be pleased to know. Claire, are you able to launch that? So how many of you work for an organisation that is subject to more than one privacy regime? So we've got no, UK only, yes, UK and EU, or yes, multiple regimes, so more than just UK and EU. Okay, so most people, it's a lot of organisations. It looks like that organisations have multiple regimes. A few are just UK only, lucky you, and some are UK and EU. And then the next poll, if we can go on to that, is linked to that first one. So given your status, how confident are you that your privacy governance programme does take account of all local requirements? So yes, you're 100% confident that you've taken account of everything. Then the second option is no, but you've taken a risk-based approach and you know where your gaps are. Or 3, you're not at all confident that you understand all of the local law requirements. Okay, well, the people who are in that bottom bucket, which is most people who are not confident that they've taken account of all local law requirements, I would say, do not worry, you're definitely not alone. This poll shows you're not alone. And also, I think our understanding with a lot of organisations we work with is that it's incredibly difficult to do this and know absolutely everything in every jurisdiction. So what we're going to aim to do now is give you a quick overview of all the different ways in which the privacy laws are diverging or already divergent, and then think about how do you actually manage that in practice. So obviously we've got UK-EU divergence post-Brexit, and we're seeing that both with the recent UK legislation with the Data Use and Access Act, but also now the Digital Omnibus proposals, which are taking the EU further away from original GDPR. We've got divergence within the EU. So under the existing regime, there are obviously different ways in which different member states can do things. We've got just different cultural approaches globally to the way they think about privacy. And we've also got sort of sector specific laws. So all of those different things kind of need to be overlaid and considered. And I will go through each of those briefly in turn. So UK-EU divergence, I've just listed out here sort of some of the key things that have come out of the Data Use and Access Act, which are not the same now as under EU laws. So we've got this new lawful basis of recognised legitimate interest, which enables you in certain circumstances not to have to do a full legitimate interest assessment if you can point to one of the specific recognised legitimate interests set out in Annex 1 of UK GDPR. So if that's for things like sharing data with public authorities when they need it for a public task, or for crime prevention, investigation, detection, that sort of thing. So sort of public sector focused types of activities. We've also got the slight relaxing of cookie consent requirements in the UK. Obviously, under the Omnibus proposals, we've sort of gone away from the EU approach, but maybe if the Omnibus proposals come into force, we'll go back together again. But at the moment, that's different. So in the UK, for certain basic sort of website analytics cookies, you don't need to get consent, although you still need to respect opt-outs. And we've got mandatory data protection complaints requirements coming into force in June this year, but only in the UK. And the automated decision-making rules. So Jenai talked through some of the proposed amendments in the Omnibus in relation to automated decision-making rules. We have already implemented a more relaxed approach under the Data Use and Access Act in the UK, so that is permitted, provided that you have certain safeguards in place. But even if the Omnibus amendments came in, they wouldn't be the same as our UK amendments. And then overseas transfers, we have got now a statutory requirement under UK GDPR to do a data protection test if you are doing overseas transfers on the basis of standard contract clauses or BCRs. At the moment in the EU, you've still got the requirement to do a transfer risk assessment, but that's as a result of Schrems 2 rather than it being a codified legal obligation. And the test is slightly different. So we've got sort of essential equivalence under EU law, whereas our test is sort of more like a not materially lower, which is potentially a slightly lower standard than the EU standard. So all of that, those are quite specific and quite narrow divergence between UK and EU, but it does mean that if you want to take advantage of UK relaxation of, say, automated decision making, but you've got a sort of processing that also happens in the EU, you have to make a decision about, well, do we now have totally different rules for our UK operations versus our EU operations, and have, that's more complicated. We have to do 2 sets of policies and processes, 2 different sets of privacy notices, and different training because it's different rules that people will be applying. Or do we just think, actually, that's too complicated, we'll apply the higher standard and we won't take advantage of the UK relaxation because it's just too complicated to do it differently in different jurisdictions. So although it's helpful to have relaxation, it does mean if you're operating in multiple jurisdictions, you have to make that decision about the approach you're going to take. And then divergence within the EU, this has been the case ever since GDPR came into force. So there are certain things, although GDPR is a harmonising law and is supposed to make everything sort of the same across all the European member states, GDPR itself specifies certain things that member states either need to implement in their own legislation or can, if they want to, implement in their own legislation. So, for example, special category data processing conditions. When you look at GDPR, it talks about, there's a public interest condition, but it specifies that you can process special category data if it's in the public interest, which is laid down either in EU law or in member state legislation. So you have to go to every single member state law to work out what is permitted under their laws in relation to public interest processing special category data. Employee data, there's an ability for member states to impose additional conditions and restrictions in relation to the processing of employee data. Criminal offence data, there are different approaches to exactly how widely that is defined. So, for example, in the UK, when we implemented it, we included like allegations of criminal offences and other things that you don't necessarily have in other member states. Then there are derogations for public sector and national security, which are defined specifically in member state laws. Similarly, the exemptions for freedom of expression and journalism are defined differently in every single member state. The thresholds for when you need to appoint a DPO, the GDPR sets out certain thresholds, but member states can basically make it mandatory in even more situations if they want to. The age of a child can be determined by member states between certain ages, so from 13 to 16 is generally the range. And then all the enforcement actions and procedures are all subject to member state law. So the exact way in which the regulators are constituted in each jurisdiction and the exact way in which they can exercise their powers are all totally different. So even under GDPR, if you are looking at implementing something in Europe, you very often still need to go and check locally, are there additional things in this jurisdiction that we need to take into account before we do this? Then we've got different cultural approaches. So this is more on a global scale. So in the EU, we have a kind of fundamental human rights approach. So people have the right to privacy, right to human dignity, and that is very much drives GDPR. Whereas in the US, it's more of a market-driven approach. There's a consumer focus on like the California Consumer Protection Act, etc. So that results in very different sets of rules. We've got some countries, it's a much more state-centric approach where they are, for example, in China, there are many wide-reaching rights for the government to use data, but much more strict rules for companies. Some countries very much have a consent-focused approach. So in Asia, particularly countries like Thailand, Vietnam, require consent in circumstances where it just doesn't work under GDPR because it wouldn't be considered freely given. Some countries have data localization requirements. So Russia requires data to be about Russians to be stored in Russia. China prohibits certain types of data to be taken outside of China. And there are also different focuses on what is sensitive data. So there's culturally what is considered to be particularly private and sensitive. There are different approaches in different countries. So for example, in Kenya, certain collection of information about your family is particularly protected. In India, some states have banned using phones to take photos in sacred places because that space is considered to be particularly private. So lots of different ways in which those cultural norms affect the laws. Then we've got sector-specific laws. And so obviously we've got HIPAA in the US for health data. Things like clinical trials regulations have their own laws. AI rules, obviously, we've got layered on top of that. Special rules about children's data, financial and credit data. So depending on the sector you're in, you may well have additional laws on top of the basic privacy laws. So how do you go about managing all of this? So the things that I think you need to think about are, first of all, what is your remit? Are you only supposed to be looking after the UK, or are you supposed to be looking after Europe as well? Are you looking after the whole world? So make sure that's really clearly defined so you know what you have to tackle. Then look at what laws actually apply in those jurisdictions, which will depend on where you're operating and your sector. Then you need to have discussions internally about the following questions. Do you want a global approach or do you want it to be local? Do you want to try to take the most permissive approach whenever you can, or are you going to meet the highest standard everywhere to try to make it as uniform as possible? What is the company's risk appetite? How willing are they to take a view on things and not necessarily go and take local advice everywhere? And then once you've got answers to all those questions, you think, well, how on earth do I then implement that? What resources do I need? Do I need local experts? Do I need external support? Do I need a whole team internally to help me manage this? And then in terms of how you go about mapping that out, I think the first steps are map your processing operations, know where you're processing data, where it's being used, what systems you're using, etc. Then you can identify the applicable laws. Then once you know the laws, this is a painful process. There's no way to get around it, I'm afraid. You need to list out all the requirements. So know what's in GDPR, know what's in US state laws, know what's in sort of APAC different requirements. Then documenting your controls, identifying where there are conflicts, because sometimes different laws will require you to do things that are actually opposed, and you might have two regimes applying. So then you need to make a decision about how you're going to approach it. And you need to overlay over all of that your kind of risk-based analysis and align that with your organization's preferred approach. So there's a very much a fact-finding initial thing you need to do so you really understand what the laws are. And it may be that you, because of lack of resource or ability to do everything all at once, you need to take a risk-based approach to that, to think, well, where do we know regulators are particularly active, or where do we have a lot of people that means that we've got a higher risk, and just start with those jurisdictions and build out from that. So hopefully that's helpful to give you some thoughts about how to start trying to think about how you manage the sort of divergent laws across the globe.